Thanks everyone for joining. As always, if you have questions that come up during the recording, feel free to write them in the chat and I'll be looking there. Otherwise, I think we're good to dive in. Question number 1 is from Jay, who is on the call today. And he said, do you have an update on the New York fraud case against the Trump organization? I only hear about the criminal ones.
Got it. So Letitia James, and this is a really sprawling one that she brought a while ago. It does have substantive overlap. Yeah, there is an update. He's been trying to stall, but there's a trial set, I want to say August 2nd. Actually, I have it around. No, it is October 2nd. And most recently, Trump, as he has done, all the way around, has done a filing, must have more time. It's kind of ironic in a way because more time with Letitia James would translate into a logjam with the election potentially. And just today in the Manhattan DA court, the judge there, Merchant, said we are definitely, we have a firm date of March 2024, causing Trump to glower and do that with his hands because that's in the middle of the campaign season. But anyway, it is set for October 2nd, and in general, his hijinks have so caught up to him. I just at the procedural level with these various judges. So we'll see what happens to this latest effort to stall. But in general, the different judges have been shutting it down and even saying, no more briefing is necessary, etc. So it's a big behemoth case. It has it overlaps a fair bit with different kinds of fraudulent misrepresentations and the like, and the Trump organization criminal suit, and it is headed for an October 2nd trial date, and I think something like that will probably hold. So yeah, look for it in 5 months.
All right, Good to know. The next question is, what is the procedure for allowing grand jurors and jurors to learn the contents of highly classified documents in a prosecution for theft and disclosure of such documents?
That's a really good and sophisticated question. And the short answer is they kind of can't. The real issue, this is something called, there's a version of blackmail that comes down because when you have a case that involves these documents, you have high-level negotiations between the criminal division folks who want to prosecute and the national security folks who want to keep secrets protected. And it will usually not be part of the grand jury proceedings, but still you have to turn it over to the defense if you are going to use it. That's one reason why typically defense lawyers have to get top secret clearances just to work as defense lawyers for their clients, and why, if there have been cases where the evidence has been strong, but it's necessarily involved the use of some classified documents, and the national security folks have had their way. But the basic idea is it's not for the grand jury, which, by the way, a grand jury secrecy doesn't apply once the grand jury is done. A grand juror can go out and gab to the world. So it's usually not part of the actual indictment, but then judges and defense attorneys are given clearances, and they negotiate out some version, some non-classified version, by definition, if it's going to appear at trial, to use at the actual trial, and it can get dicey. I don't think we're going to have that kind of trouble with Mar-a-Lago. We're talking about fairly old documents at this point, and the actual content of them doesn't really matter very much. What matters is that they were, in fact, classified. So if Trump tries to, do that stratagem, I don't think it'll succeed because we don't care so much what the secrets were, just that they were secrets.
This is from Becky, who is on the call with us. Since Timothy Parlatore apparently is saying that Boris Epstein prevented him from doing a thorough job of searching for more documents at Bedminster, etc., Does that give DOJ probable cause for a search warrant for those locations since the documents case is still ongoing?
Ooh, good one, Becky. Okay, so does everybody see this? They had probable cause to search Mar-a-Lago, and we had maybe probable cause, at least people seem to believe he still had things, but because the Fourth Amendment requires stating with particularity where they are, any other, they couldn't actually make the case out to the same degree of constitutional certainty with respect to his other places. Now, really interesting point by Becky, which is that in these, in Parlatori's kind of, departure with Peake, he did make it clear that the Bedminster case that he was foiled by Epstein along with many other things. Remember, though, that there was a search there, and it happened supposedly voluntarily. Plus, it's, we're talking about Parlatori, I believe, is talking about in the post-June period. So it does seem to me that even if that's a pretty good indication that at least that there may have been some in Bedminster back in May or June, doesn't seem to me it would pass constitutional muster for showing that there's now probable cause to believe that they are, there in May of 2023. But very ingenious, and you should apply to the Department of Justice Honors Program.
Absolutely. This is from Ed, who has written it in the chat. Will we ever see the redacted portions of the discovery materials from Dominion voting versus Fox?
I think not. So I'm a dissenter here. I really think, I'm not a dissenter in the sense that I totally understand what Dominion was doing, and they did have a very big payday, many times their own worth. But the public value of the case for just really showing that Fox was flagrantly lying and didn't have a leg to stand on, and then information like this, right? We have in the reports following the case the suggestion that Fox was desperate to settle because of that Tucker Carlson racist, about white men and stuff. And that was something that had been redacted. I think this is why Fox wanted to do it. Don't have to apologize. It's now a sealed case, so it would really come down to leaking, basically, which is not out of the question, but it's not a pending case anymore. And Fox, it's one of the reasons they were wanted to settle, even at a pretty high price tag, although 20% of their quarterly profits, and then you have a tax deduction too. So there's no clear legal avenue for getting it. I don't think a FOIA, it's not public documents, so you can't FOIA it. I don't think we're likely to see it, and it's a shame.
Another question, a little more broad. Can you please explain how it's determined whether cases need to be filed on the state or federal court?
That's another really good one. So the short answer is it's determined by the plaintiff. And the plaintiff will file in the first instance in state or federal court. Now, there are requirements if they want to file in federal court. You can always file in state court. In federal court, it are courts of limited jurisdiction, and you have to make a showing either that it's federal law, or it doesn't have to be federal law. It can be state law, as long as you have what the Constitution and the lawyers refer to as diversity, meaning that the plaintiffs and defendants are completely from separate states, because one of the reasons that the framers wanted to create federal courts in the first place was to permit people to, get supposedly a fair shake and not go to one or the other. Now, there are procedures, and we are going to see them, for removing a case that's filed in state court sometimes a defendant will have a right to remove that to federal court. In fact, that's what happened with the E. Jean Carroll case, the one that actually she's just tried to amend her complaint on. It was filed originally in New York State court, and it was removed to federal court based on, a series of pretty technical requirements under the federal rules. But state versus federal courts, in theory, federal courts sitting in diversity apply the same law, but everybody knows it can be really different, that a federal court judge might be a little bit more, well, it has a different vibe. And more importantly, for some cases, it has a different jury pool. So look to Fulton County, which is, now anticipated to come forward in August. Trump's going to try to remove that to federal court. So a state criminal law action, Georgia v. Trump, in federal court, that's like a law school exam already. But one reason he will want to is there's a different pool for jurors. One has, it has to do with the whole county, and one is by voting, and I forget which is which, except I know that the federal one is much more favorable to Trump, more likely to get some MAGA faithfuls there. So that's going to be one way in which it's really going to matter practically. But basically, plaintiff decides, and then in some instances, defendant can remove a case from state court to federal court.
Okay, interesting.
Did that answer? It's a little. That's a tricky legal question.
Yeah, no, I think it did.
Yeah. Okay.
Yeah.
All right.
Since you mentioned E. Jean Carroll, we have one about E. Jean Carroll. If E. Jean Carroll decides to sue Trump for reiterating his slanderous comments about her after he lost the first trial, will she have to reprove that he sexually assaulted her? Are there any parallel case types that we can look to for guidance? And then they said, I'm thinking pollution cases where the polluter loses in court but continues to pollute, things like that.
Right. So, a really good question. Again, you guys are on fire today. But let me make clear, because this has been really misreported broadly. I've been on TV a lot today, and people have been really butchering this. So let me just say, E. Jean Carroll has moved to amend her complaint, not to add a new defamation count based on what Trump said in the CNN town hall. Rather, it's the same complaint, one count complaint that she filed in 2019, and that at the time the Department of Justice came in and said, we want to take over this complaint because he was acting in the scope of his employment was Trump. And if that were to happen, it would be curtains for the complaint and the cause of action itself. What she's now saying is, I want to add some more facts still about this 2019 case, because some things he said in his deposition really help us. Like he said in his deposition that he had only mentioned this to his wife and daughter, and that tends to make it less likely he's acting in the scope of employment. He was just so nasty and crass. She thinks that grounds a claim for punitive damages, again, for the 2019 original case. Now, if she wanted, and this came up a lot because he's done it at least twice, totally reiterated his claims. Could she bring another defamation lawsuit just based on, oops, he did it again? And I think you put your finger on it in the question. He could, but it would be, the damages wouldn't be very impressive, because it would just be what has accrued since the verdict 2 weeks ago or whatever. And I think I've been on the minority here, but my best prediction has been she doesn't do it, because why rock this boat? She's really, I think, got vindication. It's a verdict that not just gives her, decent payday, but also really, I think, serves to show Trump as a liar for the way he's kind of, tortured her over the years. So she could, every time he does it again, but it wouldn't be for much damages, and it would have some downside. In the meantime, what she has done is move to amend the original complaint because she thinks she can make a stronger claim that he wasn't in the scope of employment. One final point, the Department of Justice last night filed a letter that asked the court to decide the motion to amend the complaint before it states its position, which the court had asked it to do. That suggests to me that if the court lets the new complaint in, including the new information about his state of mind, maybe, just maybe, the department will consider changing its position. Remember, Garland sort of stayed the course that Barr had first established, and that's kind of Garland, the institutionalist. But I'm sure there was they had to swallow hard to do it within the department. And if there's now a new factual case, so it doesn't look like they're just changing for political reasons, they might.
We have a follow-up from about redactions in the chat from Peter. He says, will we ever see the redacted portions of the Mueller report or the 1/6 House Committee report in appendices?
My best guess is yes. So that for one, those are governmental documents, and there's always going to be a FOIA. But I just think the process there is after all things have played out, and you can't make claims of defendant's prejudice or whatever. I think we'll see that. We should see that. But what I mean by we should is it is right and prudent for the nation to see it. And in addition, I think the legal mechanisms are there.
All right. We have a question from Eric Lane. I believe the 14th Amendment insurrection clause was successfully used to disqualify a local candidate who participated in January 6th from running for office in New Mexico. How can you establish standing to bring a lawsuit under this clause, and who has done it?
So correct. And brilliant question from Mr. Lane. And let me just say, I mean, it's such a puzzle here. So in the wake of the Civil War, written into the 14th Amendment, maybe the most important and powerful clause in the modern day Constitution, is something that just says in flat out terms, anybody who has sworn an oath to defend the Constitution and then committed insurrection against the United States is ineligible to hold public office going forward. Now, how would you generally do it? And the way, so here might be the simplest way to think about the puzzle. First, the clause states a qualification to hold public office, including president. There are very few of those, and the Supreme Court has already ruled you can't add to them. But it is no different in terms of its constitutional footing than having to be 35 years old. So who has standing to challenge a president on the ground or presidential candidate that he or she is actually not 35? Now, the way it's worked in the past is a voter does. So somebody is put on the ballot, and you can do and this is what happened in the one case you're talking about. You can go to the local elections judge and say, hey, this person shouldn't be on the ballot. He or she is not qualified, and the local election court will adjudicate that. This is presumably what Trump was after, at the beginning of his national campaign, and trying to say Obama was not, born in the United States, which would have disqualified him. Now, we never thought about this in terms of this 14th Amendment injunction. And to cut to the chase, and then I'll go back a little bit, it's a puzzle how you can in the wake of the 14th Amendment, there were many the Congress kind of by fiat prohibited certain Democrats who had, in fact, this described them, they had sworn an oath and committed insurrection, kept them from, and that was the idea of it, kept them from being in Congress. But then they granted a general amnesty, said we wouldn't do it anymore. Then, though, in the 1920s, really interesting, a socialist was elected from Wisconsin, sent to Congress, and Congress, using the 14th Amendment, because it was in the wake of the World War I and bitter feelings, bounced him. and he went back to Wisconsin, was reelected, came back, and they bounced him again. He eventually came in. So that would suggest who has the power? Congress. And in fact, there's a real worry that if it came up, that the court would say, we don't have the power, political question. On the other hand, let's say Trump is indicted for insurrection and the system adjudicates him the way the system does. A jury decides, it goes on appeal, et cetera, would seem to be as solid a attestation that he has violated the 14th Amendment as there is. But kind of then what? So to my mind, first, it's a puzzle. And second, notwithstanding what happened with that one state guy, they also tried it, by the way, with Madison Cawthorn and a few others unsuccessfully. But notwithstanding what happened to that sort of penny ante guy, in the case of Trump, it would, that wouldn't be a governing precedent. And I think basically what you'd look to do is have both Congress by majority vote. It doesn't have to be 2/3. It just this fine, but both Congress and a court, jury, etc., find it, and then anyone brings it up. But if the Supreme Court at the end of the day says, that's not enough, or it's just hortatory or whatever, it feels like an insoluble puzzle, even though it is a clear as day constitutional command. Does that kind of get as far as we can, Eric? All right, I got a thumbs up. All right.
Good. All right. We have a couple questions on the debt ceiling. First, Can you explain how it would actually work for Biden to invoke the 14th Amendment on the debt ceiling issue? Having trouble understanding it, and what would happen next?
Yeah. Again, 14th Amendment, the most powerful. And it says it says again, it's a clear constitutional command. You may, the debt of the United States shall not be questioned. And to be clear, this is the sort of rhetorical and political point that the Dems are making. What the cuts that the Republicans are insisting on aren't cuts in the sense of reduction of the budget going forward. They're cuts in the sense of actually trying to renege on already established obligations of the United States. So there is this provision in the 14th Amendment that says, well, that can't be done. It doesn't say exactly who can't do it. Certainly doesn't provide any remedy. So we have the same kind of puzzle that it's there, but we don't know who can effectuate it and how they effectuate it. Nevertheless, here's I think what they're actually considering. So Biden just referred, so, there have been some really, really interesting scholarship on this and people who have endorsed it as the lesser unconstitutional action than simply reneging on the public debt. But the idea is Biden says, hey, look, 14th, first of all, who is really violating the 14th Amendment? McCarthy, the Congress, et cetera. If Biden just notices there's no money in the Treasury, I don't think he's violating the 14th Amendment. Nevertheless, there's a sword here that he could try to use, and it would go something like this. Look, my constitutional oath says I cannot do anything to effectuate this. I understand I'm not supposed to borrow. That's Congress's job. I understand there are things I'm not going to do, but I'm sorry, I'm not going to violate the Constitution. So I can do one of two things. You're allowed to make coins, and so he's gonna, that's the idea of the $3 trillion platinum coin. He just mints a coin, calls it worth $3 trillion, and then puts it in the Treasury. Clink, we've got $3 trillion to play with, and then alternatively, he goes out and borrows, not as we normally do, but it would have to be in the private marketplace, higher interest and the like. And either of them likely would be challenged. Interesting standing question here, who would challenge it? And maybe it goes to the Supreme Court and the Supreme Court says, you just can't do that, even though there's the constitutional command, you weren't allowed to do that. Although the court might say, based on what it said before, if they didn't get too Republican about it, they might say, this is not for us to weigh in. This is a political question. But if they strike him down, and I think the people who are strategizing about this in the White House think it's very possible that they would, a year and a half would have passed. The crisis would have passed. He would have had it would have passed the red face test. And now we're, for all we know, the Congress has changed hands or whatever. So that's the notion. Clear command, very unclear how to effectuate, leaving an opening to possibly, do something dubious on the argument that it's, better than the alternative, and then leaving it up to the courts. And that's the way to stave off the immediate crisis.
One more debt ceiling question. I'm also wondering if you can give a bit of background on raising the debt ceiling and how it's usually done without all the drama. Are there any laws or regulations about how this should happen? If not, why?
No, just a simple vote. They've done it again and again and again. They did it 3 times under Trump. We're getting to a point where we need more money, and they just raise it. There was some suggestion that when the Dems held the majorities, they should have just raised it to $1 quadrillion, or like a billion, gazillion, whatever, so you could never reach the ceiling. But it happens all the time. It's completely routine. What McCarthy and company are doing is absolute unprecedented, game of chicken. And what they should be doing if they were following precedent is just a straight up vote of a bill. Biden would pass it saying, the debt ceiling is hereby raised to blank.
All right, back to some Trump stuff. My question is, what do you think Trump would do if he is the nominee in 2024 and loses? How long could he keep things tied up in courts regarding the election results? Do you think he'd go with the court route or just try another insurrection?
It's kind of an imponderable, that sort of thing with Trump. It is true that he could be setting things up. It's real. He's doing this dual track, right? Except they are in competition with one another. All the trumpeting that he does on the campaign trail hurts him legally. So, I'm once burned and twice shy, of course. I am a Democrat, even though Talking Feds is nonpartisan. In 2015, I was, like, wow, if this guy gets the nomination, the Dems will roll. And, joke was on me and the country. So it does seem like he's really the odds-on favorite for the nomination, and there's really the odds-on favorite to lose. But man, shit could happen, including something to Biden. So, but if he wins the nomination, but loses the general, if he's not in the White House, I think his options are really limited. He can jump up and down and call out the Proud Boys, but it was always the case, including January 6th. And this is sort of how terrorism works in general, that the official force and power of the police of the United States was much, much stronger than the ragtag terrorists, but they were caught by surprise. Nobody would be caught by surprise this time. So, he could scream and jump up and down, but I don't think it would work. And we're now, I think, coming to the point, his lawyer, his Ty Cobb, remember the sort of handlebar mustache guy, actually said on TV last week he thinks he's going to go to jail. I find it pretty easy to imagine he get indicted, pretty easy to imagine he get convicted, pretty hard to imagine actually going to jail if it comes to it. Although, just today in the New York court, the judge threatened him with criminal contempt. That means jail. But so, I just think in that scenario where he hasn't won, if he wins the presidency, all bets are off, right? But where he hasn't won, I think his ability to do mischief would be quite limited, and some extra legal broad, peace will be sought where, we don't see him in a jumpsuit with his his hairdo finally revealed, and instead it's just he goes away. But it's pretty weird because the crimes he's going to be charged with carry large jail sentences, and if you're really serious about equal application of the law, you send him to jail. But I think it's always been a little bit incomplete or unsophisticated. Every person is the same under the law. I just think it'll be an extra step to actually stick him in jail if he's convicted.
Got it. This is a related question. Which of the many potential charges against the former president, carry the caveat that he cannot run for public office, if any?
Yeah, great. So that is indeed what we were talking about in the 14th Amendment in the insurrection clause. The court has said you may not add to the qualification. There was a case involving Adam Clayton Powell, if anyone remembers him, in the late 60s. He was doing all kinds of nasty business. The Congress kicked him out, and court said, sorry, here are the qualifications in the Constitution. You can't add to them. So the thing that would kick him out and say he couldn't hold office would be a finding that he committed insurrection, because the 14th Amendment says you can't swear an oath to the Constitution and then commit insurrection. But so that would be the nature of the charge. And I don't think it would have to say insurrection in the code, but it would, I think it's enough if he conspires to, insurrection basically consists of trying to foment violent, obstruction or impairment of the government. I think that would be enough to trigger the constitutional command, but now we're back to 10 minutes ago and what would actually result in a final judgment by presumably the Supreme Court, backed if necessary by the 51st Airborne, that says you can't, go forward. But that's what it would be, and only that, but maybe not even that, is that he's committed insurrection.
Okay. With Trump continuing to threaten directly or indirectly witnesses, law enforcement, judges, etc., is it likely or practical to keep adding charges to the list? How much time before a set trial date can charges be added to that particular docket?
Yeah, that's a really good question. And because, what's he doing day in and day out? Obstructing justice. And in addition to that, he's also, tainting a jury pool and the like. We saw one attempt to, assert the majesty of the law today. It was in a Manhattan court. Trump was attending from Mar-a-Lago with flags behind him, but the judge, while Trump seethed, the judge said to him, look, if you violate this protective order, this is my order. I can put you in jail for criminal contempt. Whew, talk about a chicken game, and would a judge actually do that? At a minimum, I think he'd have to find, violation after violation. But my best guess is absent, they got enough charges on him, absent some real videotaped, brass knuckles job by, who would it be, Steve Bannon or Stone or Powell or whatever. I think the charges will be the charges, and if he tries to monkey around with public opinion or witnesses, it'll be the job of the judge in that individual case to try to rein him in.
Okay. And we have one final question about
that was
timeline.
Fast. Let's take two.
Well, do we have any other?
I see a dog.
Have a follow-up. We have a follow-up in the chat.
Oh, if that's all we have, yeah.
We have a follow-up in the chat, and then we'll go to the final question. This is also about the redactions in the Fox case. Will Smartmatic have access to the discovery material from the Dominion case? Could they unredact any of it?
Great question. And I could go on for a long time about why the Smartmatic is not the salvation that people think it is. You cannot have, not just willy-nilly. They can't, Dominion can't just turn it over. And then if they do, they'll be subject to a lot, to the same protective order. So the short answer is maybe, but not in a way that solves the issue that we've been talking about.
Okay. And the final question, if there aren't any others in the chat. Hold on. Sorry, we do have one more in the chat while we're here. Could Trump receive home confinement if convicted? Is that an option?
Yes.
This is from Jay.
Yes, remember the guidelines now, they used to be pretty determinate, and now a judge can, kind of do whatever she or he wants. That would be a very, I think, likely kind of scenario, especially, I mean, it's going to be hard to give him home confinement if you convict him of, something with a 10-year minimum or whatever. Though judges can, still have a lot of discretion, but I think home confinement is a very plausible scenario. And, I think he could muddle through at Mar-a-Lago having, cheeseburgers and guests and and fulminating every night.
Yeah. And do you think Jack Smith will invite before Fani Willis at this point?
Yes. Close,
Okay.
but Fani Willis has basically said August. And, today's report in the Wall Street Journal makes it seem like, we're really at the end game. Now, of course, the end game with Jack Smith is not the end game with Department of Justice, prosecution memo to Garland approve, etc. But, but Fani Willis has said, 2.5 months. I think it'll be before then.
This is just from me, but what is the normal timeline for a special counsel referring it to Department of Justice for the department to make a move on it?
You mean for it to then work out? That's a really good question. I basically don't know the answer, except it's the same. A special counsel here will prepare a prosecution memo, and it'll go to the attorney general. In any case, like a line prosecutor prepares a prosecution memo, and it goes through supervisors up to the U.S. attorney. Normally, so that process on its own, just on the merits, is a week. But we're indicting the former president. Garland will clearly, convene his kitchen cabinet to include Smith, talk it through back and forth. There has to be at least a day warning to the White House. So look for, several weeks, I would say.
Okay. Thanks
all everyone. We have See you next
today.
month. Yeah.
Thanks, everyone. Talk to you soon.
Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.